crystals, pyramids. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Welcome home, family, and join us for the fun. Colorful guests, people everywhere under the sun. Interesting conversations. Prayers first has begun. Invocation, manifestation, conversation then will come. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Let's start drinking some water, juice or tea. King Killer's recommended for you and me. Guayusa mixed together, maple syrup or honey. Magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Learn from the healers, crystals, pyramids. Learn from the healers, the artists, the seers, authors and teachers, dissolving your fears. Workshops of wisdom, the circle is wide. Plant medicine whispers, the planets align. All magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Crystals and pyramids, magnets that spin. Organ awakening the power within. Tantra and herbs, the gateways ignite. Shamanic drums calling truth into light. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Psychedelics painting vision so bright. Planetary activists guarding the night. Awareness expanding the cosmos in view. Higher vibrations are flowing through you. Magnets, crystals, pyramids. Yeah. Magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Xenon and herbs, you'll feel much better. Drink your tea now instead of later. Stay ahead of your health. Health is always your greatest wealth. Oh, no, no. Magnets, crystals, pyramids. Hey. Magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Mad science fun, tell the bless. Experiments under the sun. Sacred fire, prayers begun. Success and happiness, your destiny has come. Magnets, crystals, pyramids. Yeah, magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Learn from the healers, the artists, the seers, authors and teachers, dissolving your fears. Workshops of wisdom, the circle is wide. Plant medicine whispers, the planets align. Oh, magnets, crystals, pyramids. Yeah, magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Oh, crystals and pyramids, magnets that spin. Organ awakening the power within. Tantra and herbs, the gateways ignite. Shamanic drums calling truth into light. Magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Magnets, crystals, pyramids. Magnets, crystals, pyramids.
magician, the lover in you. Every single day, we are called to walk in our purpose. Answer the call. Lay down your burden and anything that holds you back and take your rightful place. The battle is everywhere. It's right in your face. Let's go.
Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alameen. Ar-Rahmanir-Rahim. Maliki Yawmiddin. Iyaka na'budu wa iyaka nasta'een. Ihdina siratal mustaqim. Siratal ladina an'amta alayhim. Ghair maghdubi alayhim. Wala dwalleen. Alhamdulillah. Dr. Sanada Kamara, co-founder of Temple Mother Earth, sending love, peace, and abundance prayer to everyone around the world.
Welcome to Magnets, Crystals, and Pyramids. Success is your destiny. Love, wisdom, power. Remember always who you are. Yes, yes, I am. Love, wisdom, power. Yes, yes, I am. Love, yes, power. Yes, I am. Yes, I am. Love, wisdom, power. Yes, yes, I am. Wisdom, power. Master. Yes, I am. Yes, love, wisdom, power. Yes, I am. Say to yourself, yes, I am. Yes, I am. Master. I am. Yes,
Long ago, in the valley of time, I lived a life, I lived a life with you. Long ago, in the valley of time, I lived a life, I lived a life with you. But Lord, I'm crying out for you. Lord, I'm crying out for you. In the valley of time, I lived a life, I lived a life with you.
Welcome to Moorish Monday with Abdullah Talib, Mosi Bay on Magnets, Crystals, Pyramids YouTube and Moroccan Post Media YouTube. Welcome. Yes, the title of today's presentation is Learning Law by the Principles. We're waiting for Brother King to come on. And here he is. He's been with us. He's been on this platform about, I guess, 7, 8, 9 times
Yeah.
in a 2-year period.
Yeah.
Yeah, so definitely. So welcome. So those who just joining us, please hit that like button. Let people know that we're live. Um, if you haven't subscribed, please do so. And so I'm definitely excited. Uh, my website, as you just appeared, mooresandmasonry.org. Anyone who would like to get any of my books, go to mooresandmasonry.org. All right, so we're gonna get right to it. So we have learning law by the principles. Learning law by the principles. Can you have that light?
I'm
Right?
trying to up
Yes.
that
Uh,
bright
uh,
light.
Yeah, there you. Yeah, because it was like so. Probably.
Okay.
Yeah, because that light's right above you. Yeah, you don't want. Yeah.
This way. I'm gonna turn this way.
Yeah. Turn. Yeah. Turn. Yeah. Yes. There you go. Absolutely. Because that was definitely.
It's kind of, I can't see nothing. Like it's got.
What do you mean you can't see anything?
Okay, there it go.
All right. All right. Learning law by the principles. King, before we get started, I want you to. Though it's been a while since you've been with us.
Right.
I think the last time was with the class, the course, the trust and legal safeguard course, the trust and legal safeguard course we had the back in July. It was either I think June. We had the student testimony. That was the last time you were with us.
Yeah.
We had about 6 or 7 of the students in the class. So just give us a little background before we get started.
Yeah. Just a little history on King L. Bay. Started off in law. Um, just curious, going through issues like a lot of Moors find themselves. They're trying to see or seek something out. Um, once I once I started off learning law for us, I started in the area of child support, and then it was just so intriguing to me that I studied and kept continuing to study. And what I have learned through over the years, I've been doing this for maybe 16, 17 years now, that I started seeing certain patterns. I started looking for certain things. I was used to just research and just, parrot what I heard from the Supreme Court. I didn't understand the logic always behind their thinking process. So it was certain things that when I read excerpts, Supreme Court excerpts, I didn't always fully get a grip of what they were saying until I started reading more, and I read some things about principles of law and the rule of law, and I started really digging into that. And what I had noticed, there was a certain way to think about law. It's not just by posting statutes and putting words on paper and calling it law. It's a certain philosophical process of thinking, understanding how to think like a jurist with my ability to start understanding there's a set of standards of practice of rules that you have to follow, like in every um, everything that you do. There's a set of rules. If you think about math, there's a certain set of rules, things in a bracket, things outside a bracket. There's a understanding about a particular thing when you're exercising a particular subject matter. And what I learned, there's rules to law that you must follow, and is led me to understanding these principles so that now I could be more sound when trying to deal with a case. So throughout the years, once I learned these principles, it kind of evolved me to another level where I was, work on cases and different things like for myself, and people would come to me with, and I had information, and it seemed to work. And I started seeing there was a pattern of me constantly having victories in court based on these things. Once I really identified, um, I started noticing there was just a way of going about thinking and challenging certain things about how the proceedings and stuff like that. And I can't remember, it was a case, I can't remember the case, but it was just breaking down. Um, it was talking about due process, and it was talking about, it said that the court, all they care about if you was afforded due process of law. Your innocence and guilt is not by the Supreme Court hands. That is by your jurors. That's by your own peers. You get judged by your peers. We the only thing the court do is afford you due process. We must follow these rules and stuff like that. So when I read that, I said, I need to understand what they're thinking, how this process. So when I started understanding jurisprudence, the philosophy behind legal principles, to understand what a legal principle was, so I can understand the elements of that legal principle, which is like the DNA, right? A principle is a is a particular principle, but it's made up of different elements, and those elements is the DNA. Just like you are a unique person. Every individual, you have a set of DNA, right? That's unique to you, and based on that, they can identify who you are based on that DNA. It's similar to the same process. Based on certain sets of principles, when they set a precedence or set a principle in law, it's made up of particular elements. And in order to perfect a claim when dealing with and using such principle of law, you must meet all those elements. And then you, based on the elements, you saying, okay, these are the findings, these are the elements, and this is what I found, this is what I know. These elements, I found these elements in my situation, so I'm going to use this because the law has already been concluded. When something of this nature is pretty much have been identified in the same similar way, I'm afforded the remedy before someone who came before me. But if I'm setting a precedence of something new that hasn't been really established, then the court is going to look at everything and say, based on what he's presented, this is setting a new standard of how to deal with this. For example, technology shaped the world all the time. At one point in time, motor vehicles was a thing of the new. It wasn't a thing of old like we have now. Everybody have a car. But the thing that we have to understand now is that at a time when motor vehicles was just being created, there wasn't motor vehicle laws. Somebody get hit by a car or anything else to there wasn't laws there to put certain things in place. So they had to start thinking about that and set a precedence on that. Now they develop into more into a civil nature by creating statutes and stuff like that. So once you understand these things and these elements, you'll be able to break down the law, and you'll be more sound, technically sound, and more proficient on getting a remedy and understanding how to challenge, not jurisdiction, challenge any person's position based on if they met those thresholds, based on those elements based on the principle that they're trying to use, and asking that the court give you the remedy because the court has already concluded this already. There's was a stare decisis. Um, um, the court has already ruled, and they already made a founding on this. So there's no need to take someone through all of this because you met that threshold. So once you understand the principles, you get better at it.
Can you mention that there is a formula? You mentioned about a formula. Also, we talked. You mentioned doing a contrasting learning law by processing or learning the philosophy of law.
Right.
Or can you go into that?
Okay. Once you understand, the court says one of the things you're going to hear the Supreme Court. I kept hearing over and over in their process. They say in their their excerpts that you must think proper. What do you mean by thinking proper? So there's a formula to law. You must understand certain foundational principles like operation of law, source of law, application of law, rule of law, findings of facts, conclusion of law. You must understand these things to be able to appropriate what you're doing so that you can be um, very accurate. And when you speak to the court, they know that you're being very specific because law, a lot of times, is very, very specific and tailored to a particular subject matter, and you must understand how to do that. So, how I learned when I started understanding jurisprudence is the philosophy. A philosopher who creates a based on the law, right? And we understand when the Supreme Court makes a ruling, right? It's a certain type of thinking that has to go into place. There's a training of the mind with jurists. They have to understand how this works in order to be able to identify and be able to say, okay, we can rule in this based on our understanding of the law, and how it's supposed to operate and behave. So, what I have done and what I've seen with other jurists and with the courts, what they do is they understand the philosophy, which help you identify what the principles are. So, if you want to understand the formula, is the jurisprudence equals the principle plus the elements plus the findings plus the conclusion of law. And you can look up all of these things. You can look up findings of facts. That's in your criminal rules and civil rules of procedures. You have conclusion of law. It's called findings of facts and conclusion of law. You can also look at principle, right? And then you can also look up elements, right, that have to be found in a particular principle. How's this principle is made up of? So when anytime they create a statute, there's a certain thinking of legal mind that thinks in a particular manner to understand how law is supposed to operate and behave. And with understanding the formula jurisprudence, right, to understand the principle, because you only can understand the principle when you truly understand what jurisprudence is. And once you understand the principle, then you can understand, okay, this principle is made up of this particular elements. And these elements When you look up things, you're saying these are the findings of facts. These are the findings. You find those elements existing in your particular case, and here findings of facts. Here are the same facts. Then you can determine what the law has already concluded. So you don't have to go about trying to reshape or reform the law. They already done it. They already, a lot of this stuff is not new to them. So you just got to understand how the law works. So based on that formula that I was using, right, I learned the law. When you learn a process, you don't understand the principle. You pretty much is parroting because you don't understand the thinking or the mechanisms of law. So what you would do is now people just create things to make it sound good, and they don't understand all the elements. So we were talking the other day, and we were talking about statehood and all of that, and people talk about nation building, but they don't even understand under international law before you can have a state. What is the elements necessary to have a state? And these elements must exist in this particular round of statehood. When we talk about statehood and we talk about sovereignty, all of these things is rooted in a particular ideology that's dealing with a set of principles, right? International. Then these elements got to exist in order for you to make such claim. That's how you perfect a claim, by understanding this formula. And when you don't do that, you pretty much cheat yourself. Now you just parenting. You saying I'm nation building, but you don't have a territory. You don't have uh, a group of people who have elected a government. You haven't you saying you are within a territory that never identified you and recognized you as a sovereign state or relinquished such territory over to you. You don't have any of those things so that someone can say, here's my findings of facts. Here's our relationship with the United States or whoever. No one, a lot of people talk that, but they don't understand the breakdown. So here come more misconceptions when you don't understand how the law is broken down by principles to understand the elements, to understand what the findings were that was found, that was used in an evidentiary standard, right? Rules of evidence. Now you can produce these findings as evidence to support. It says, well, based on this, that, and the third, under international law, this has already been remedied, when we're entitled to that same remedy to be made whole again. And most people don't, they can't think on those levels because they're thinking about certain things and dealing with certain legal processes. You know, get you a trust, status correction, all of these things. You know, trust are in law, but status correction is not. Nobody is teaching the managements of trust or anything. They don't understand the principles associated with a particular type of trust. So all they do is parrot and say you need something, and you don't even know why you need it because you don't understand the principle to understand the elements so that you can produce these findings of facts necessary to say the law has already remedied this. Here's the conclusion that the law has already found to present and be able to perfect your claim and win based on something that was already awarded to everyone else, granting equal protection of the law. And most people don't know how to process that and think in that manner, so they don't know law. They just know a bunch of legal definitions that they're saying. And law is bigger than just reading Black's law definitions. It's bigger than that. It's bigger than reading case law. It's bigger than that. You must understand how to think like a jurist, and the only way you're going to do that is by learning by the principles, because that's the way you really learn. That's how you understand if you know law or not. So that law is not a guessing game. Either you know or you don't. So I've been doing this for a long time. I done had a lot of success in this. This is something that I understand that's more measurable than not. I can measure what I'm doing based on what I've known, based on what I have performed, based on my studies, and based on my exercise of understanding law. And most people don't think like this. I haven't found no one who think like me in the movement other than Abdullah. And everything that I have shown Abdullah when I came in, he looked it up. He found it. Everything that I talked about, he looked at it and found it. Oh, the rule of law. Oh, okay, I need to read that. He read a lot of excerpts on that, a lot of information on the rule of law. Oh, application of law. Oh man, I need to understand that. He read it. Source of law. Principles, legal principles. He read it. Elements. He read everything that I have explained, and it be able to resonate. See, it's a lot of pseudo law. There's a lot of people teaching you things. They don't understand how to look at all of this legal stuff to really be able to exercise this with precision. So you get somebody telling you this and they can't tell you why. They can't go into a deep explanation why. They cannot break it all the way down. People tell you, well, the court is not going to be able to tell you, or they're not going to tell you, they're not going to be able to show you this. You have to, then it's vague. It has, and if it's vague, it violates due process. If someone tell you that the court is not going to show it to you, they're not going to reveal it, then is that law? Because they guaranteeing the equal protection. So if someone's telling you that they're going to hide the truth from you, then is it law?
Absolutely not. This is good,
So
brother. This is good. Yeah, this is also there's a what's been out there, King, is go into the role of the role of the judge, the role of the defendant, the role of the prosecutor.
okay,
And I'm saying that because it's been out there that to challenge the judge. It's been taught. Go back and be going back and forth with the judge. Challenge the judge. Going back and forth with the judge. Challenge the judge. So go into defining the role of the judge, defining the role of the prosecutor, and the role of the defendant.
okay. So when you understand how to think proper about law, you understand what the judge's role is. The judge is only there to make a ruling on law. He doesn't even, the facts is determined by the jury. And the judge, if he's acting as juror, he's going to look at the basis of the facts that he's found. It's not him bringing the claim. It's the prosecutor. It's the state. It's a plaintiff. You don't argue with the judge about what he's doing in the
Oh yeah, and also the role of the plaintiff. Yeah, plaintiff, defendant,
right.
prosecutor,
The prosecutor
jury.
acting as pretty much the complaining party. He's the complainant, and he's acting in such capacity, bringing in a claim before the court, trying to say that you need to go to jail based on what they found. And your job is not to argue with the judge about the judge's that you're challenging jurisdiction, that they lack jurisdiction. and all of these different things. Your job is to see what the prosecutor has brought before the court and challenge whatever he brought, understanding how to think proper so that you don't get caught up going back and forth with the judge and the judge get irritated with you and rule against you because you're not even arguing law. You're not exercising anything that has a basis in law. So now you're exercising something that's pseudo law outside of law. And they're looking at you, it's like you don't understand what you're doing. So now they're going to move accordingly because you didn't even defend yourself properly because you don't know how to. Because you
Can you give
just
us a detailed example on how to um, challenge the prosecution?
Okay, so a lot of times when we looking at, there's two types of due process, and we got to understand this from what the due process clause represent. So you got to understand that, and I can get into a little detail about understanding your fundamental rights. So when the prosecutor bring charges against you, he fill out complaint. He turns it in to the judge, and the judge is looking at the complaint to determine that he does all the requirements and necessary to bring this claim according to due process, right? So what most people don't understand is how to go about doing this.
You're not on your screen. What's going on? You're blank.
Somebody's trying to call me.
Oh,
Somebody
that's what happened. Somebody called. All right. That's why he's all right. Go ahead.
So what happens is, right, when you're talking about due process, you looking for things that the prosecutor.
Don't you continue. Why are you moving around? What's going on?
Nothing. I was just moving around.
Yeah, you don't want to do that. That'll be
Okay.
distracting. You want to
Okay.
be stationary. All right.
Okay. So, um, when you start understanding what due process is, that's a constitutional guarantee, right? And now you start looking at what the prosecutor, how he performed his duties, because everyone have duties. The judge has duties, the prosecution has duties, and even you have a duty. And you must understand the law to be able to get remedy, because if you don't, you're going to be locked out, what they call barred, especially if you don't do it in a timely manner and appropriately.
All right,
So,
go back because I think we were a little distracted about the prosecution.
okay, the
Um,
prosecutor, let's talk about the prosecutor. So the
uh-huh.
prosecutor, he's the complaining party. He's bringing a claim against you, whatever it is. He's typing it up, and then he has to meet a certain threshold in order to perfect the claim against you. You have to get notice. You have to, if you getting if you going before you getting indicted, he must go before a grand jury. If it's not, then it's in a presentment in front of the court. It's not necessary. It's a felony. If, anything felony or high misdemeanors, you can get indicted. Low things, traffic tickets and stuff, it's just a presentment before the court, and it must be done in a particular way. And you must understand your state rules to understand how that works, and the rules of professional conduct and judicial rules of canons and conduct. You must understand all of these things to see if everybody is meeting their duties. So you don't go in there and argue with the judge. You're going in defending yourself against the prosecution. So a lot of people talking about, well, don't go and argue. They tell you all of these different things, and that you shouldn't do all of this before the court. And it's not that you grant jurisdiction; they already got jurisdiction.
What are some of the things, King? What are some of the different things that people that are out there?
They tend to challenge jurisdiction, right? And they already got it because they got territorial jurisdiction. We with already in the boundaries. Once you understand under international law, because if you don't understand the international law, you don't understand how they gain jurisdiction. You don't understand how they have jurisdiction. So a
So
lot
what?
of people,
So what King is talking about is one of the core principles of international law is territorial sovereignty, and the foundation of territorial sovereignty, territorial jurisdiction, is based in the territorial sovereignty. So they have territorial jurisdiction because they have territorial sovereignty. So that's what King is talking about. I mean, they through various cession treaties with France and the United States of Mexico and Great Britain and Spain, United States acquired territorial sovereignty through these various land boundary cession treaties. Therefore, they have territorial jurisdiction. Then you, as a result of Article 4, Section 3 of the Article 4, Section 3 of the United States Constitution, which tied to the Northwest Ordinance of 1787. All right. You have the mission of new states, and as all of that clause, states are admitted, and on the certification of Congress. So it's all tied to that. And so, go ahead, King. I just wanted to give more background.
thank you. You did a beautiful job, my brother. So you have to understand these things. So when we talk about subject matter jurisdiction, you got to make sure, like when we talk about subject matter, like a criminal case, right? They're not going to hear that in bankruptcy court. It got to be proper venue. So if they got the proper application of law dealing with a criminal matter, right, based on a statute, and they're in the proper venue, then they have jurisdiction. Regardless if you're innocent or not, right? They still got jurisdiction. That's how they perfect the process. That's why due process is very important. And when you don't understand how to think, then you can't challenge due process, and you can't say they did something out of order that is required by due process. This is why that's why it has to be procedurally sound in order to perfect their process to be able to even hold you in that courtroom.
Mhm.
To even bring you in the courtroom, those processes must be perfected.
And this
And to
has not.
bring
And this has nothing. This, as far as the claim being brought to the court, has nothing to do with the judge. The
nothing to
judge doesn't bring the claim.
no, he's just a referee. He just hears the matter. And it's up to you to sway the judge by understanding the findings of facts to show that they didn't meet certain thresholds for due process, and that this claim, since they violated due process, they waived any rights to even proceed. But you got to understand that. You going in there talking about, oh, I'm going to, that I hear a lot of people saying, oh, I went down there and I did something equitable, or whatever they're doing. And they don't understand that equity is birth, due process is birth from equity. The rule of law help shapes what they're doing now. It's equitable in their dealing. So you got to understand, equity is being fair, right? when you think about something being fair and honorable, right? That's pretty much equity in a sense. That's equity. So you weighing something to see if something was unevenly yoked, if something was more favorable, did they create a more favorable condition for another person to win than not? Creating a situation more than likely 80-20 chance for somebody else to win because they created a situation for them to win, right? So you got to understand that. So when you look at that, you can now you're able to identify certain things when we're talking about due process. And you got to understand all of these different things, you know. If you go down there and you put a bond onto the record, you do this, you bonded and all of these different things, right? And that you go to jail and this and this and this. No, and I mean, some of these things have some merit, but because it's based on things that's missing, it doesn't give you remedy because they're giving you part truth, which is a lie, and any part of the truth is a lie is a lie. It makes the whole thing a lie. So now y'all not getting remedy. This is why the movement is stagnant because you don't understand how to think possible. You don't know how to think proper. So now because you weren't learning by the legal principles, which you can just research. You're not understanding the principles of law. You're not understanding law by the principle. You're not understanding law through jurisprudence to be able to understand what is the principle that I'm looking for, what is this formula that I'm looking for by understanding the jurisprudence, by understanding the principles to determine the elements necessary for an individual. It doesn't matter if it's state or non-state or a regular person. Um, to understand how to perfect their claim, and then going down the line, looking at the findings to say, here's the findings, here's the evidence that supports my legal position based on this excerpt from the Supreme Court that I have met the qualifications that's necessary to give me the same remedy that Charles had before me or whoever who got the remedy. And here's what the court has concluded. And here's what can be concluded. Now you can write your own court order and ask the court to give you a remedy based on that.
Awesome. Awesome. Because as you mentioned, it's been taught that get the judge's bond, get the judge's oath, and there's no discussion about the prosecutor. It's the judge's bond, the judge's oath, challenge the judge, and going back and forth with the judge, and and that's where a lot of conscious morals have. That's how they've been taught. Todd, King.
Yeah, that's how. And so this is where the movement go. So now they're challenging the judge, and now the prosecutor is moving freely and setting you up for the kill, fatting you up for.
Setting up for the kid.
Yeah, he's fatting you up like, oh yeah, he's arguing with the judge while you distracted doing that. He's building this case and got everything you need, and you didn't file an objection. You didn't file all the different things to be able to support your position and defeat his. So now you get
The judge, the prosecutor's over there quiet, ain't saying nothing. You ain't saying nothing to the prosecutor. The prosecutor's you going back and forth with the judge, back and forth. You're not going back and forth with the prosecutor. You're going back and forth with the judge, and prosecutor's over there.
over there
Yeah,
getting
that's
filed, and so that's where it get lost at. So a lot of people just don't understand this. So they talk about a lot of different things dealing with remedy, right? And start dealing with these. You know, I hear people, yeah, I got a bond, I got a trust, I got a bond, I put my bond in, and the court dismissed their case and all of this and all of that. Man, they got, I put my birth certificate into the case. All of these different things. I'd be like, where they get it from? Show me. So when people, cause law can't be vague. Law got to be very specific. It got to either come from the General Assembly. It has to come from some Congress. Show me the
hmm
law that support it, because you can't tell me it's working and you can't identify me the source of law, the findings of facts, the application of law that tell you you can exercise such authority. You can't tell me that's how law works. Okay, when somebody tell me they can't show me, then I know they lying. Show it to me. Because law cannot be vague. It can't be vague. It can't have vagueness. That's due process violation all day. It cannot be vague.
all
You
right. Go ahead.
1001. Okay, let's see it work. What do the UCC say? Because the language in the statute is going to determine everything. Everything. I'm gonna use the UCCs. Okay, you're using the UCCs. Let's look at it. Let's see it. Or they're not gonna tell you this. They have to tell you. They have to rule. And if they're not telling you, then this is not law. Because law is supposed to set a precedence so everybody else can get the same remedy. If that remedy, if everybody got that under that same scrutiny, that's falling under that same situation that it's already worked out. But if you got a law that works against, it says everybody who found guilty of this going to jail. It works the same way. You going, it's because law is to give remedy. Either you going to jail or you being exonerated. You being found innocent. Law is to give remedy. Or you don't have law. You have tyranny. It's tyranny.
All right. I want to, you know what? I'm going to go to some questions early. Type your questions in. Go to some questions early. Type your questions in. Oh, man, you cooking, brother. Got some questions. We got some. All right. So let me read some of this, King. All right. Santi Il Bay. Understanding the principles helps one better understand the precedents that's been set by law on which its foundation was set on the same principle. Setting ill, the volume is very low also. You said the volume is very low also. Ah, wow. Is it? I didn't get that. I hear him just fine on my end. Is the volume's low? Because that was at 3 to 7:30. Volume good on my end. All right, so we have Raheem. Raheem Bay 2707. Volume's good on my end. When Brother King is speaking earlier. Oh, when we speaking earlier. All right. No problem. Just Byron Harris, 5754. Peace and respect, family. Is it true? This is a question, King. I guess it's for me and you, because I can. This is outside. we won't go. This is outside of that. I don't want to go there. This is outside of the doctrine of discovery, the Vatican. This is outside of that. This is outside of the discussion. This is outside of the topic. Today is learning law by the principle. I don't want to bring that because that's gonna. It's just. I don't know. We're not going to deal with the doctrine of discovery, the Vatican, because then that's a whole another presentation, and it's not. Yeah. So let's just stay with. Ask the question based on what you've heard, or clarity on what you've heard. You're not going to get into the doctrine of discovery. That's another. That's where King.
You know what, Abdullah?
Yeah, it's because it's not. It's because it's outside of this discussion, King.
But
Go ahead.
when brothers be talking about the doctrine of discovery, let's utilize the process of law. Let's use the application. Let's
All right.
go to the source of law. Let's break this down. Okay. When we talk about a doctrine, a discovery, a decree, someone decreed something, and they say, well, we're going to decree this. How could a country decree something else to another country? There's processes that we are missing. This is why these questions are coming out, because they can't think proper about law. When you start understanding international law principles and you understand international law, well, I'm not talking about all the history behind it. I'm just talking about the process that's being used to be able to allow that to have force. They make a decree. Do that automatically mean that a Moorish state that once existed said we're going to honor that decree?
Well, the doctrine of discovery you're dealing with territorial claim. Doctrine of discovery is dealing with the territorial claim. All right. So we're going back to 1500s. So we're going back to the late 1400s. All right. And so we're talking about territorial claim of conquest, acquisition of territory, discovery, conquest, subjugation, military occupation, colonization. So here was the doctrine of discovery, inter terra divina. That's why I said I didn't want to get into it. I don't. Let's move on. Let's move on. Let's move on, King. Let's move on, because I already know it's gonna. It's I don't, because I don't like to be. I don't want to be vague. In order for someone to really understand, I can go in. Right. Israel and I, when we do the preach, we can go in order to really understand. We want to be detailed, naming the doctrine, going there, going to treaties, the process, so they can understand. They're not going to understand with vaguity, because it hasn't. All right. Because what it is, King. Because I know what they've heard different presentations from not from me in Israel. Because we're clear. We break stuff down. We go in. Doctrine of discovery, doctrine of discovery, doctrine of discovery, doctrine of discovery, pontifex, doctrine of discovery. All right, doctrine of discovery. Then they're as in going in. I can go in, but this is not the presentation. That's why I went there, but I'm not just realized I was talking. It's just getting away from the presentation. Let's move on, King. Let's move on to another question, y'all. Type your questions in, because it's just gonna get away from. I don't want to get away from the presentation. Okay. Let's stay with that, let's type our questions in. I won't even. In fact, I won't even. If I hear this, I won't even read. I'll read past stuff like that now. I'm not gonna. Yes. Luisa Flores, where can we look? Where can we look or seek the core 5 laws of our rights in the court of law? Is that
Yo. So you first of all, we talking about United
you
States.
understand? You understand the question?
Yeah. So the Bill
All
of
right.
Rights.
Can
So
you
first,
clarify the question? Can you clarify the question for audience?
me,
Yes.
she she asking where could we find, um, I guess, codes that dealing with our rights.
As that it's CORR the number 5 laws. Is that a typo?
CO, what is COO? What?
Louisa, put the in again because that might be a typo. You have a typo here. You have COOCORR number 5 laws. Just look at your question, Louisa, and then just retype it. Just clarify your question.
So first, we got to understand the Constitution to look at the Bill of Rights. What did the Bill of Rights afford, right? And then we take it from there because this can get very sticky in talking about what our rights is. Because you can have rights under contract, you can have rights under administrative duties and stuff like that. Dealing with various government agencies, dealing with government contracts, dealing with a driver's license. Those are those the BMV. They set a stage. These are all different agencies that can dictate certain things based on their authority. So when we start talking about code of rights, you have to be very, very specific and not general. You have to know what institution that we're talking about and what institution and regarding to what. Because you asking, you question, this is the thing you always want to solve. The who, what, when, where, and how. That's the riddle that you must always think in your head. What am I solving? Who's the who, who's the what, where's the where, and where's the how? You got to understand that when you're dealing with things. We got to get out of asking these general questions that doesn't they doesn't blanket, they just blanket something but doesn't answer or give remedy. Because we start talking about things, when we talk about law has is very specific. When we talking about constitutional, you got to talk about the Constitution and Bill of Rights. If you're talking about the BMV, talk about what they have. They have a Bill of Rights. They have a certain. They have. You can look all of this stuff up. You can go to the BMV and look up what their Bill of Rights is. You can look up everything according to what they say. And they have an administrative due process. They have all of these things. You could go to the various institutions and look up what their rights and duties are. So when we start talking about what, these different rights, regarding what? Be very specific because law is very specific. You're not going to court dealing with criminal law in a bankruptcy court. Two different venues, two different subject matters, and two different forms of rights dealing with the particular subject matter and that particular agency that governs that particular venue. Law is very particular, it's very distinct. So when we say what our rights is according to this and that and the third, I don't know what to give you a remedy because that's a answer that needs to be very tailored and specific to what you're trying to do and what particular agency.
She here it is. She had all right. Where can this is Luisa Flores? Where can the public seek to start studying the laws? How to use our rights in the court of law. So where can the public seek to start studying the laws? How to use our rights in the court of law?
Now, that's even kind of still vague. So I want us to understand this. If they is she talking to Moors, unconscious Moors, Europeans, what is that? So if say, let's talk in general, if she was talking to Moors, Moors need to start studying international law to understand their position here, understand their original status, right? So now they can start putting things into a proper context so they can understand these applications, these principles, and all of the different stuff that I've been talking about and utilizing this formula. Moors must start there because we have a unique circumstance and situation to a lot of other people because we're in under subjugation. So we're in a very particular situation that a lot of other people are not. Based on the subjugation that we have, this is why we are identified as black, Negro, and colored. It gets into real deep information once you understand certain things. So you got to learn these principles from international standpoint and a domestic standpoint, so you can always think proper. Because once you learn how to think law and you understand it by the principle, you will stay in the proper thinking. You won't be all over the place. You
And
understand what I'm
yes, I know where you're going. The let's look at the case, the Justice Daniels. Justice Daniels and the his and using the principles of the law of nations and the Dred Scott case, Dred Scott versus the Sanford case, and Justice Daniels and using lengthy quotes from the Law of Nations by but the book called Law of Nations by Emir de Vital. And one of the in deliberating on the Dred Scott case, Justice Daniels stated that those of the African Negro race, those that the African Negro race, having never been acknowledged or belonging to the family of nations, and to the fact that never been anything partaking, never been recognized or anything partaking of the character of nationality, of civil and political polity. So let's say why. So why did King say why conscious Moors need to study international law? Now, just Jasmine Crockett, like I said her name, she's a public figure. Jasmine Crockett, and I love that sister. I love the fight that she has. Jasmine Crockett will refer to Justice Daniels' statement as racist. She will call Justice Daniels a white supremacist. She will refer to Justice Daniels as a white supremacist. She will refer to the statement as racist. You know, white men, you know what I mean? That's a white man and statements and they white supremacists. And Justice Jasmine Crockett, because she doesn't know what we know, that know who we are, she would, because Justice Daniels look at African Negro race. And so she would, Jasmine Crockett would not see that Negro, because the statement is correct in the laws of nation, that Negro, African Negro race, Negro have never been acknowledged as being recognized as belonging to the family of nations. That's a correct statement. And that there was never anything partaking of the character of nationality and civil and political polity. Let's look at the principle. Well, Jasmine Crockett would overlook all that and she got a law degree. You know what I mean? She was a defense attorney, and she's a representative. I mean, she's a representative in Congress, and she would not identify the Negro as not having character and nationality. That's major. That is major. This is my dear sister Jasmine Crockett, law degree. The House of Representatives. Jasmine Crockett will call that a racist statement. That is major. Negro is a Spanish word. Negro is not an English word. Can never, ever, 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 ever be an English word. It's a Spanish word. Let's look at the grammar. In Spanish grammar, Negro, its grammatical function in Spanish is that of an adjective describing inanimate objects. Negro zapato, black shoe. Jasmine Crockett will not go there because she think Negro. She will see like Negro, like that's a people. Like Negro's a people. You know what I mean? And so she would just and the sister Jasmine Crockett, I love you, sister. Jasmine Crockett, I love you, sister. I love the fight that you have. I know, Jasmine Crockett, you love our people. I do not doubt that. I've never questioned the love that you have for our people. I'm not questioning that. I love you dearly, sister. But my sister, that would be a huge error. That would be a huge error. That would be a major oversight. Justice Daniels is direct in that statement. Let me get the actual statement. Justice Daniels in that statement is directing us to remedy. Just give me a minute here, King, because this is major. Because you brought up in answering our dear sister Louisa Flores' question. You stated that conscious Moors need to study international law. You are actually correct. And this is Jasmine Crockett. In that statement, Justice Daniels is giving us remedy. And Jasmine Crockett would overlook that because she would give credence to the word Negro. All right, so let me here we go. I got it. This is one of the statements. Justice Daniels was writing his deliberation. He was writing his support against Dred Scott. Justice Daniels was against Dred Scott of dealing with the issue of citizenship. And Justice Daniels was writing his support. He used the law of nations. He quoted heavily from Emir Dead Vital Law of Nations book, which was written in the 1750, I think 1754, and the Federalist Papers, 88 articles. The Federalist Papers consist of 88 articles written by John Jay, Alexander Hamilton, and James Madison, and they quoted heavily. And the Federalist Papers put in the context. I got to put everything in context. The Federalist Papers were written in 1788 and pushing and for the support of the ratification of the United States Constitution. As you know, after it was signed in 17 September 1787, the delegates of this 13 states went back to the respective states. They held debates, ratification debates, Federalists and anti-Federalists, and those articles was written to push for the support of the ratification of the United States Constitution. Alexander Hamilton, James Madison, I think Thomas Jefferson quoted heavily from Amir de Vital, the Law of Nations book, which was written in 1754. I got to put everything in context. So, so Justice Daniels also quoted heavily from de Vital's book, The Law of Nations, and showing his support against Dred Scott. So one of his statements, based on the principles of the Law of Nations, Jasmine Crockett, that the African Negro race, and she would overlook that because she would give credence that Negroes are people. See, that's a major mistake. He's giving us remedy, Jasmine. Jasmine Crockett is just giving us remedy. That the African Negro race never have acknowledged as belonging to the family of nations, that as amongst them, there never has been known or recognized by the inhabitants of other countries anything partaking of the character of nationality or civil or political polity. That this race has been by all nations of Europe regarded as subjects of capture or purpose. Now, Jasmine Crockett, once again, will refer to this as a racist statement by white supremacist males. I mean, she would call them white, which is not a nationality, white does not identify existence of anyone. This is Justice Daniels is directing us to remedy.
This is why it's so important you understand, you teach by principle, because if you understand the principles of statehood and you understand the principles of international law, you will know how to operate to get remedy. And when you don't teach by these methods, when you're operating outside of law because you're teaching something that's pseudo, that has no legal basis, and it doesn't have any findings of facts, conclusion of law. It's not an application of no law, right? It's not a principle, so you don't know the elements, so you can't define it because you don't understand that. To understand the jurisprudence that's been going on all this time, to understand how law is supposed to work and behave. And when you don't do that, this is what we have: a community that is confused, that doesn't understand how to think about law, how to get remedy. Because that's, at the end of the day, that's all we're seeking anyway, is remedy. And that's what law is supposed to equal, is remedy. It's supposed to equal remedy. And we got to understand our position as Moors, even conscious or unconscious. We got to understand, what is our status? Because I hear people talking about, oh, status correction. You got to understand, if you understand principles of law and you understand you cannot enforce a treaty individually. If you understand statehood and you understand principles, you cannot enforce a treaty as an individual unless there was provisions in that treaty that says you can exercise such power.
Okay.
It has to be.
Yeah, and I was called you have a rights of action. If it has a rights of action, individual rights of action. If there's an individual, it's called an individual rights of action. The 1787 treaty between the Emperor of Morocco and the United States does not afford in that treaty individual rights of action. Why, Abdullah? Dummy Abdullah. Why, dummy Abdullah? Because Articles 20 to 25 are extraterritoriality clauses. It delegates only counsel, a Moorish council regarding, for Moors, and then United States council. So that's right there. I'm just right there. That's why that was called extraterritoriality, conspiratory, or extraterritorial consular jurisdiction. When you have that clause, it doesn't give a individual rights of action. That's why. That's what I just wanted to just clear that up. Principle of treaty. So we're looking at principles of treaty. You have individual rights of action. So
And
that's what King
you
is
got
called. So that's why that treaty does not. Other treaties do, because all treaties don't have extraterritorial clauses. But that 1787 treaty between the Treaty of Peace and Friendship between Morocco and the United States does.
And what do that mean, extraterritorial jurisdiction, as it relates to this particular treaty? That means that counselor can come in within that jurisdiction and exercise certain powers. Only counselors have that extra territorial powers. It doesn't say individuals.
Mm.
Law is very specific in its language. So when we start talking about all of these different things, you got to understand how to think proper about the law, or you wouldn't be saying these things. Once you understand it by the principle, it'll make so much sense to you, right? Individual rights of actions, you see that within the United States. They got statutes that says individual rights of actions. You have rights of actions. This is why what corporations can sue and be sued. They can sue government. You got to look at a lot of these things. Individual being Abdullah had talked about all these things that you talk about, individual rights of actions. We have discussed all of these subject matters. You talking to about two individuals. Abdullah sent me so much literature that he reads all the time, but it's a different. He's not reading to read. He understands the principles that embodied what's going on to be able to understand and appropriate what they're doing. Because if you don't understand the principle, then you're not going to understand. All you're going to do is regurgitate what you read. Because you don't understand how law is supposed to work. You're going to read a definition and you don't even know if the statute violates any constitutional provision. You won't even, we don't know some of these statutes. No one is challenging, right, a constitutional challenge on the makeup of such statute, that it overreach. It's congressional overreach. It reached in a private way of life that was never meant for Congress to have. So when we start talking about these different various subject matters and treaties and all of these things, doctrine of discovery, if you understand these principles, you wouldn't be answering these. You will answer your own questions. You will know how to look at these instruments. These instruments are within the authority of a particular jurisdiction. You can't you cannot decree something that affects a state that has its own territory, its own people. It has everything. It has met everything it needed within that what? And we're talking about perfecting claims. How do you perfect a claim? It's easy. Even when we talk about the doctrine of discovery, I want y'all to think about this. And I'm going to make this real simple for you about all of these different things, right? If I'm claiming land, I'm going to say me and Abdullah have land. Me and him got a dispute over land rights. The court is going to want to see the contract and what that contract entails, right? And then they want to see how did me and him come in possession of that land? Where is any land deeds? Where's any sale? When you buy land, they call that purchase agreements. Where are all of these other transactions, right, that can verify our position? Right? When you understand what law requires, when you understand it by the principle, all of those other questions go out the window because you understand how you supposed to think about law. Not some of the time, all of the time. So when the court looking at me and Abdullah and they're trying to figure out how could you make a claim that this is your land and that you have these rights, now we got to look at all the other elements that pre-exist to give me such right to do that. It is based on principles, statehood, international law, treaty agreements. Once you understand all of these components, you will stop asking all these frivolous questions. What application of law is being used under international law? As we as Moors understand our status, we got to understand we are in a unique situation because most of us don't understand the term subjugation to its fullest extent based on our current status right now. What was our original status before now? Who were we before now? Because you telling me black people was a artificial construct that was created. It has no basis in international law. That's why you can't get remedy for black people because it don't exist. There is no language in international law talking about black people. You might hear human rights and all
No,
of this.
no character, having no character of nationality.
So,
Having never been known or been recognized. That's using just using law of nations. Going to Vitale's. All right, Justice Daniels, who quoted heavily wants to quote heavily from Vitale's book, The Law of Nations. Having never been known or recognized, acknowledged or recognized as belonging to the family nations. Having never by any inhabitants of any country having been partaken of the character of nationality or of a civil or political polity.
and if you
Like
do, it's called finding of facts. Where's the fact? This is all principles that's derivatives of law. When we talking about these things, we talking about findings of facts. That's a legal principle, findings of facts to produce. So if there's black people that's been recognized under international, right?
that's a violation to even recognize that. That's a we conscious meaning Jasmine Crockett is committing a violation. Let's be clear. I love you, sister. That's a violation to push for quote black people to have any rights. That's a violation. We can't push that
You
because
can't put
that's not a people. I mean, if you're talking about civilization, law of nations, if you're talking about humanity, human rights, if you're talking about the law of nations, the family nation principles, you cannot push for fiction had never been known or been acknowledged as belonging to the family nation, having no character of nationality or civil political piety, to have rights. That's not a people. That's a fiction. That there's no existence. That's also white. That's so equal opportunity. Let me do equal opportunity now. I will always use white too. Equal opportunity. Black and white do not identify any existence of humanity, human being. Doesn't identify, white and black do not identify the existence of a people's nationality, national origin, ancestry, lineage, descent. We cannot push black and white to have any rights because it's not a people. It doesn't identify a human being. Doesn't identify anyone. It doesn't identify belonging to the family nation. That's black and white. We got to bring them into the real world. That's fictional. So not just black. Hear me out, my brothers. Come on, conscious Moors. The same thing y'all been saying about black. However long you've been conscious. However, hear me, please hear me. However long you've been conscious, everything you said about black, say about white. However long you've been conscious, everything you said about black, say about white. You already know what to say. Just substitute it. Let's put white there. Let's put white there. Put white there. We have that equal because we got to have balance. Because white doesn't identify the existence. And ain't no is. Donald Trump is white. No, he's not. Donald Trump is Scottish and Irish. Scottish and German. The verb to be is, that's the etymology of the verb to be is existence. White doesn't identify any people's existence, nationality, national origin, pedigree, belonging to the family of nations. So we could put white there too, all right? The white race, never been known or been recognized as belonging to the family. I said, let's put white, let's put here, let's do this. That the white race, equal opportunity, y'all. Equal opportunity. That the white race never have acknowledged as belonging to the family of nations, that as amongst them, there never has been known or recognized by the inhabitants of other countries anything partaking of the character of nationality or civil or political polity. White's not a national. Everything you said since you've been conscious about black, say about white. It applies. White's not a nationality. White doesn't identify people. Those are facts. But we weren't using equal opportunity. We've been unfair. We've been unfair in our practices. Conscious Moors have been unfair in their practices. Conscious Moors have not been practicing equality. They have not said the same thing about white. They've been unfair in their practice of, they have not been equal. They have not applied equal opportunity. So shame on you, Conscious Moors. That shame on, say the same thing about white. Say the same thing about white. We got to get them out of, We must get them, those of English, Irish, Scottish, French, Polish, German descent. We must get them into the real world too. Equal opportunity. You know, say those of English, Irish, Scottish, French, Dutch descent. So Donald Trump is not white. By my calling Donald Trump white, well, he does exist. So why am I saying he's white? I mean, he does exist. A King, Hank, King is back. He had dropped off. You hear me, Hank? Brother Hank. Brother Hank. I would have to drop off to call him. All right, so this is we have 30 minutes. Brother Hank. All right, what I need to do. I need to give me 1 minute after drop off to call him. All right, we're back. You know what? I never dropped. I thought I dropped. No.
Okay.
All right. So I just wanted to just to give that clarity there, and because you tied it in very well, King, with the principles of international law, and I wanted to read the Justice Daniels statement again, and I wanted to bring up, like I said, I brought up Jasmine Crockett, that would not be, this is where the lack of our knowledge, they're playing on our lack of knowledge, and so we get into this emotional, that they're white supremacists and racists and white supremacists and racism. We in that emotional, and I've said that Jasmine Crockett, and I'm using her because she's at the forefront of pushing that. She's very visible. And because she's in Congress, and she constantly calling Donald Trump and the others, the Republican males, white supremacists and white racists and white supremacists, and she's pushing that, it sounds good to those who don't know, but it ain't good to not recognize that Justice Daniels is pointing to a remedy. That's a grave error. To call him to not recognize that he's pointing to a remedy, though. That's the whole point. That you would because that's a pointing to a remedy. Hold on. African, of course, that because this is not a people. Negro. What's wrong with the statement? Based in the principles of the law of nations. Nothing.
Nothing. So if it's not a principle, right, then that means they don't have a basis in law because there's no application that exists to give them remedy. This is why I say you must understand this formula. Jurisprudence, right? Principles to understand the elements, to understand the findings of facts and what the law conclude. If you're not thinking like that, I can put that in any situation under international or domestic law, and it's going to give me what I'm looking for because it's measurable. It's not a principle. Black, Negro, colored do not fall under the statement, under the standard of statehood, under which relates to a nation of people, under the law of nations, nowhere. So there is no remedy because there's no exists. It don't have no basis in law. So when you push these narratives, these pseudo practices, you're outside of the threshold. You don't have, it's not based in principle. So what elements are you identifying? If you can't identify the elements, how are you going to be able to put the proper application of law to use? To say what source of law it came from. Is it international law? Is it domestic law? Is it treaty law? When you don't think like this, you're not going to get it. You're not going to get it because these issues are not new issues. These are issues that's been plaguing the world for thousands of years. This is something that we've been doing and people are not being accustomed because it's based in this pseudo law outside of law.
It's not new. People, there've been kingdoms and clans and empires 2,000, 3,000 years ago that subjugated people, conquered land, renamed and reclassified them. That's been going on. It's not new. That's just not only just part of us. It's right. The remedy's there. They don't need to deliberate nothing to write nothing. It's there already. Our sovereignty's there. Our mother's there. She's in the hospital. Our mother is in the hospital. She's been in the hospital for over 200 years in a coma. The sovereignty ain't dead. It's in dormant. It lays in abeyance, waiting for us. It ain't dead. We live and wet, we are politically dead. I mean, our mother, our state due to subjugation. So it's been a temporary collapse of our political structure. But the sovereignty is there, though. It would not be a rebuilding. We're not building anything. Right? Language matters. You don't use the word build. We ain't building. We're not building anything. We are restoring, not building. All right, let me give you a quick lesson on language. So you got a sheet of paper. We have build, the word build on the left, rebuild on the right. The word create on the left, the word recreate on the right. See what I'm doing? So when you say build, all right, what does that mean even in international law? A new state in 1968. And the International Law Commission, Rights and Duties, the United Nations International Law Commission on the Rights and Duties of States. Ceylon, in re-entering the family of nations, was classified as a new state. the representative went in front of the United Nations Law Commission on Rights and Duties of States and challenged the claim, the Law Commission, United Nations Law Commission, that Ceylon was a new state, that Ceylon was a old and original state and not a new state, and should re-enter, should be recognized as re-entering the family of nations, re-entering the family of nations as under the reversion to sovereignty as an old and original state. Language matters, because to make the claim that you're building would mean that you're not what? The sovereignty never existed. The sovereignty's there, reverting to a pre-existing sovereignty that's already there. Language matters. Language matters. I don't play no semantic games. That's so those who don't have the knowledge of language, they throw that you're playing semantics, because they don't know that language matters. So they just throw, Abdullah, you're playing semantics. You're playing word games. I don't play word games. I ain't got time to play no games. I don't play no semantic games. I don't play no word games. I understand that language matters. And reading international law cases, language matters. I've seen cases being lost on that, won on that. Language matters, but because I study that, I study language, I study grammar, I study etymology, I study semantics. So that is a keen area for me when I even read cases. Language does matter. All right. Thompson versus Thompson versus Nelson. Thompson, based on the 1818 treaty between the United States and Spain, when Spain ceded Florida to the United States. You have Nelson, Thompson versus Nelson, and United States. I think it was Percy versus Nelson, and Thompson versus United States. All right, so in Percy versus Nelson, the English version of the 1818 treaty between the United States and Spain was read. So therefore, the principles, the international, the principles, the canon principles of international law was not applied in that case. They used they read the English version. In United States versus Thompson, it was stated that in the previous case that the international canons of principles, international canons principles of interpretation was not applied in the first case. That the Spanish treaty, that the Spanish version rendered a different interpretation. Language matters. Now we're talking English language, Spanish language, rendering a different interpretation. So when I read stuff like that, it sticks out. Like, I don't read past stuff like that. As soon as I see that, I go, ooh, and it resonates with me. Like, I don't read past stuff that deals with language, because language matters. So we're not building anything. We're storing. Reversion is sovereignty. Reverting to a pre-existing sovereignty. We're not building. Well, never use the word build. We're restoring.
And you got to understand, if you're looking for a remedy in international law, you must stay within the legal framework. Anything outside of that will cause it be an error in law because you're not thinking proper. You're going outside. You can't say one thing and do another. You can't ask for remedy under international law for black people because it don't exist. That is a fictional law in which it's a creature of what? The United States. So it stays within the bounds of that territory. Once you understand principles, once you understand how to think about law and you think proper, guess what? It will guide you through. And you will stop asking questions about all of these different things. You learn it by the principle. Study international law and understand the law and the principles associated with it. To understand the principles, you first got to understand the jurisprudence, the thought process that went into creating such laws. To identify that principle, to know that those particular elements that must exist in order for that principle to have force, for you to have standing, rather, for you to have standing. Then you got to show what the findings of facts were based on the circumstances and all the things that's involved to say you met that threshold because the law has already concluded a conclusion based on the facts and the elements and the application. Now you can say this is the remedy that we are entitled. You must understand this. You can put this in international. I can take this everywhere. When we deal in the law, this what I'm talking can go everywhere and anywhere. But if you're not thinking like that, you outside of the realm. You're not thinking proper. This is why Moors are talking about status correction and going to the federal court and arguing treaties because they don't understand how all of this stuff works. Or they will stop. And once you learn principles, international principles, principles of law, you understand the things that I'm talking about, like rule of law, right? Application of law, source of law, findings of facts, conclusion of law, right? Once you understand these things, guess what happens? Your thinking process starts to change. Your ability to analyze law starts to change. Now you'll be able to identify, okay, they missed the target. And this is what I learned. I learned a lot of times the state, even in criminal cases, the state may miss the threshold. But because you didn't catch the error and didn't argue it, you lose. You lose. Because you're not studying it by the principle, you just regurgitating case
Can
law.
you give us a situation? If you can, you remember, if you can recall, where the state has missed the threshold and somebody
Okay.
lost because they didn't bring up the error.
Okay. It's so let me say this. I had a brother. Um, we was working on some things. He ended up going to jail behind it. We were close. The state had missed the federal statutes. They really it was a lot of due process violations, right? In my early phases, I was doing a pretty good job keeping certain things at bay. But because we missed, well, after I kind of walked away from the case due to certain situations, he lost based on certain technicalities because he didn't raise certain things and he didn't produce what he needed to produce to verify those due process. And the state was reaching, and it was so many violations. They knew they did it, but because he didn't understand how to make him position himself, he lost on that. And the state, and it was federal. They didn't even have what they needed to really support their position because they already had violated. It was already time barred. But the judge allowed it to go through.
Mm.
There was too many due process violations, and those are the things that when you try to file an appeal, and because you're so ignorant to the law at the time, most people be time barred. They be out of compliance with the rules. So
Mm.
now they lost on that technicality, being barred to bring the claim because they're outside of the time
Time.
constraints to bring such action. This happens not. This is a perpetual thing that goes on. Just like when we was dealing with Mike's case, on the other hand, right?
Mhm.
We won. Mike won based on what? All of the things that we were talking about,
Job, yeah.
right? And he won. But they still kept his car. He won though. The
Yeah.
court is still allowing certain violations of due process. They lost their claim, but they still was allowed to keep the car. Those who served their spouses and children in the generations that followed. The
Yeah.
court
The charges were,
violated.
the charges were dropped against them, but they were able to, they kept the court. Yeah. Yeah.
They kept the car. They owe him money. You don't get to take property, right, without just compensation. But because if you don't bring a timely action, you waive those rights. Rights are waived based on you not knowing what to do and filing outside the time requisite. Now you bar and you waive such rights. And this is a continuous condition that I see our people in all the time because we're ignorant, because we don't study law like it need to by the principles and not just reading case law and parroting or citing cases. No, you must. The court says, I've read so much Supreme Court case law, it says that you must think proper. One of the things you must think proper. I done read that so many times. So many times. And until I figured it out, I didn't know what they mean. What you mean talking about they must think proper? I'm thinking proper. No, they saying no, you must know how law behave. You must understand how this works, how this whole legal system works. Now you can be able to identify the errors in law, the due process violations, because due process, those are errors in law. That's why when you file an appeal, they say plain error. Plain error. What do they mean by this? Evident that they're operating outside of the law. They got it misconstrued. So when you don't understand these things and you don't know how to look at the law, you don't know how to break down the law because you ain't studied it by the principle, you ain't did all of these different things. What happens is you just find yourself regurgitating, citing excerpts, and trying to hope and pray that you win your case. When you understand what you're doing and you understand how to unfold this, now you start to be a little more sharper and accurate. Like people ask me, King, how did you, people used to ask, how did you know? How did you know this? How did you, things were measured. The things that I accomplished in my things in my fields of study. I put a lot of stuff to the test and measured it based on what I thought I knew. And didn't you pull up the other day and sent me that thing you pulled up? And you was like, hey, this sound like you, King. What was that?
Um, oh yeah, from AI.
Yeah.
Yeah, it was from AI.
It was talking
On
about the principles.
yeah, the principles. I looked up studying law by the principles or something like that, or the principles. Yeah, studying law by principles versus studying law by process. Yeah, that was it. Yeah, and it does sound like you because it went into the philosophy and how and the it was doing comparing and contrasting. Man, I don't.
I think I got it,
You
Abdullah.
got it. Yeah, go. Yeah, I texted to you a couple of days ago.
So what is it?
It's in black. It's AI. Yeah, don't forget to hit that like button, everyone. Don't forget to don't let people know. Actually, after this, we'll be done in a few minutes. You can share it, share the recording. I'm gonna have King on more. I'm gonna have King on more often.
You
I mean,
said
schedule's been busy, and I've had other guest speakers. I've probably had so many other guest speakers on, new guest speakers. I wanted to do that. I'm gonna be bringing King on because I had King on a lot in 2024.
yeah. It's talking about the jurisprudence as the science treating positive law
Yeah, go
and
ahead.
the philosophical and analytical studies of law as it actually exists, positive law. Focus on its principles, structure, and application rather than what it ought to be morality. Key figures like John Austin defined the formal science of positive law, examining commands of a sovereign backed by sanctions, analyzing concepts like rights, duties within existing legal systems, distinguish law from ethics, and exploring the essential elements common to various legal systems. We talked about this.
Yes,
Um, Positive law, and then it says creation enforced by human authority, sovereign legislation in specific society, distinct from natural law, universal moral principles. Formal science in the sense of being essential and analytical to, looking at the abstract structure and logic of law, like grammar for language, rather than its specific content or material manifestation in different countries. And analytical focus it seeks to understand what the fundamental concepts like rights, duties, and property and the relationship within a legal system classify rules guiding how new cases fit existing laws. According to the Law Dictionary, this Yale Law Journal articles, distinct from morality, a key aspect of legal positivism within jurisprudence is separating law, What is for morality? What ought to be thought other than jurisprudence school debates? And then let me see. It say John Austin, the father of analytical jurisprudence, view law as a sovereign command, duties, and sanctions, emphasizing law as a social phenomenon. Analytical jurisprudence focuses on analyzing existing legal systems and concepts. Legal posi- positivism, a major school that champions the study of positive law, separating it from ethics and politics. It is essential, in its essence, jurisprudence as a science of positive law is the intellectual discipline of understanding the architecture, principles, practical application of human made law. So when you learn law by the principle, right, you understand the philosophy because the principle is embedded. The philosophy is in this thinking is in the principle is embedded in such philosophy of thought or to cure something that is plaguing the society. And once you understand that principle has a set of DNA. Those elements is that particular law and that DNA. And it's that threshold that you gotta find. Okay, I met all of these different elements, whatever it is. And then you say, okay, the findings of facts. So the elements that you find, right? This is findings of facts. They become fact once you do particular things. What is that? What do you mean, King L Bay? You have strong supporting, you have other things that support that particular statement, photograph, whatever the thing is that you're presenting for the court as evidence. It has other credible um, things attached to it that give it more likely to be truthful than not. I want to say this again. When you're producing evidence and you understand how to produce evidence, you present other supporting documents and other evidentiary tools that support your legal position based on what you presented that is more likely to be true than not. This is when you really understand that based on your findings. So, you guys, when y'all talk about the doctrine of discovery, I want you to use these principles to go look back and look at how everything, how states, international law, how states is formed. Look at all of the international law stuff. Then ask yourself the question about the doctrine of discovery. Stop parroting. Learn these principles. Learn what I'm saying to you. Learn the philosophy. Learn to study it from this set. Now I guarantee you answer your own questions. Because it'll be right in front of your eyes.
Well, we at 9:01, King. I want to thank y'all for riding with us for past 2 hours. I once again greatly appreciate Brother Hank. My website, mooresandmasonry.org. Mooresandmasonry.org. King is the he is the founder and president of the Moorish Union of Sovereign Tribes. He's also the chair of the Moorish Investigative Research Committee, which was established 2 years ago. Sponsored by the Moorish Union of Sovereign Tribe, as well as the Moroccan Post School of Government and International Law. We have organized structured a council of 13. Luisa Flores is on it. Love Bey, Fahim Bey, We have myself will be on there. We have Seton Il who's on watching us now. Luisa's watching us. Raheem's watching us. Love Bay's watching us now. They're also on the council of 13. I am also the advisor. So we have Israel, who's on the council of 13. He's also the secretary, and Amanda Siegel is the assistant secretary. All right. So we are very serious. We also King Al Bay, myself, and King El Kanan Bay, who will be every fourth Monday of the month. He'll be with us. We are the speakers. We're setting up. What's being put in place is a nationwide tour, and the tour starts in Savannah, Georgia. So we'll be in Savannah, Georgia, with the date is still being set. So we'll be there. We're looking to come this way, with the tour in set either February or either August or September. And Philadelphia and New York. It'll be one day in New York, the next day will be in Philadelphia, and we'll have the sponsor for New York would be Luisa Flores and Raheem Ala Bay, who is has the Meeting of the Minds Civic Association, as well as the Meeting of Minds study group. And both of them will be sponsoring the New York, and I have the Moroccan Post School of Government International Law will be sponsoring this Philadelphia. All right, so we also will be out in the Midwest where Keng is, and we're working on determining that. And so that will be Cincinnati and Columbus, Ohio, and Lexington to Kentucky area. In the Midwest, and then we're looking at other areas in 2027. So this will be it'll be broadcast live. We'll sell tickets in person tickets as well as pay-per-view tickets. We'll be doing big time marketing. We have Brother Al-Uza, Brother Al-Tuza will be heading the marketing. And we'll be doing big time marketing. All right. Setting up the website, Instagram, Facebook, TikTok. It'll be big time marketing. And we'll be able to view it. It'll be viewed throughout the world. All right. We're very serious and we're very focused. We're very organized. All right. We must make a change. We have to change what we're doing. We must be organized. We must reach out. Also, Brother Raheem Abdullah, Raheem Ala Bay, and I will be every Friday from 12:30 to 1:30 on Harlem Radio 115. And I'll be putting out that link for next 4 months, a 4-month workshop every Friday at from 12:30 to 1:30. The theme of the workshop is the fictional world appearing to be real, the erosion of nationalities and cultural identities through the fictional racial categories of white, black, red, brown, and yellow. We've already been on there twice. I will be on Friday. I will be focusing just on white. Equal opportunity, y'all. Once again, the same thing you've been saying about black. You already know what to say. Everything you ever said about black, say the same thing about white. So I'll be focusing just on white. And I'll be maybe the next 3 weeks focusing just on white. Equal opportunity. All right, so thank you all for riding with us. All right, so once again, anyone interested in getting my books, Moors and Masonry Part 1, Moors and Masonry Part 2, How Venus Moon Rule, etymology, vocabulary, the Masonic Conference Square, go to morrisandmaestri.org. Thank you, everyone. Until next time. Peace. Till next week. Peace, everyone.